Waktu
Kai
if I may seek your Lordship's indulgence in mentioning item 3 of part 2.
Item 3 of part 2.
Yes, my Lord, if it can be taken up next week, I have taken the consent of the other parties. And the interim order passed earlier may continue till the next date, my Lord.
Item 3, right?
Item 3 of part 2.
It was fixed today, actually.
It was fixed today, so we have one fixed matter, that is item 2.
Yes.
So it might not be possible today.
Anyway, so though the matter was fixed today, Mr. Sosa, learned counsel for the appellant submits that due to some difficulties, the matter may be taken up for hearing after a week.
Yes, next week, my Lord.
In the next week. It is submitted that he has taken the consent of the other side. Allowing the prayer, the matter will be listed next week on. Shall we give a date or
Thursday, my Lord.
Thursday? We can give a date.
29-1.
29.
And interim order passed earlier may
The interim
continue.
order shall continue till the next date of listing. Don't worry.
Item 4, 6, and 8 of Part 2 hearing list, Your Lordship.
4,
Your
6,
Lordship. Yes, Your Lordship. 4, 6, and 8 of the items of the Part 2 list, Your Lordship.
criminal appeal.
Yes, Your Lordship. On behalf of Mrs. Mary L. Kyangte,
Okay.
since
You're for the appellant?
I am for the appellant in item number 4, Lordship.
I'm for the appellant in item 6 and 8, my lord.
I see. Okay. Yes, ma'am. Go ahead.
I've taken the consent of both the parties, Your Lordship, so the matter may be listed after 2 weeks.
Lordship, item number 4, as
And
regards
yes.
item number 4, this matter may be taken on 3rd of February, Lordship.
3rd of February.
Yes.
Are you agreeable to that?
Yes, Your Lordship.
No issues. And the other two on other dates.
Yes, Your Lordship. That will be fixed by the registry, Your Lordship.
The learned prosecution additional. You're for your additional PP?
No, Your Lordship. I'm on behalf of the additional PP, Mrs. Mary L. Kyangte.
No issues, no problem. Submits that with the consent of the other side. Some accommodation is requested today and phrase for fixing the matter after 2 weeks.
Yes, Your Lordship.
The prayer is allowed. List the matter after 2. So for list item 4, fix it on 3-2.
Yes, Your Lordship.
3-2. And 6 and 8
After
on
2
any suggested date, or we can fix it as per you. Item 6 and 8, you fix it on.
Item 6, 5-2. Item 8, 9-2.
Okay,
Yes, Your
that's
Lordship.
okay for you.
Much obliged, Your Lordship.
Obliged.
May I seek your lordship indulge in mentioning hearing item part 2, hearing item number 9, with the consent of the other party if the matter may be listed after 2 weeks.
After 2 weeks, which
Yeah,
item?
2 weeks. Make appeal 5 of 2024.
Item
Item
9.
9, huh?
Item 9. You're for the appellant?
Yes, Your lordship.
All right, counsel for the appellant submits that with the consent of the other side. The matter may be fixed after 2 weeks. After the prayer is allowed. List the matter on
10-2.
10,
2.
10-2. Okay.
Principal seat matter for delivery of judgment, item 1.
Connected from there. The conviction is upheld. However, I have made alteration in the sentence. The prison term has been reduced to only 7 days, and the fine amount has been increased to 15,000 each. Okay, the criminal revision stands disposed of.
Obliged.
Item 2.
This revision petition has been allowed, and the impugned judgment and order of the learned family court, Barpeta, is set aside in court.
Aizawl bench, daily list for admission, item 1.
Yes. Can keep it.
Your Lordship, in this case, the state respondents were to file an application for extension of the time for complying with the judgment and order. As per the-
You filed
Yes,
in-
it has been filed. And
in the writ petition?
Yes, in the writ petition.
Okay. But it's,
It was filed this morning. It will be in the registry.
but it's been quite a long time, right?
Yes.
My lord, the matter pertains to regularization of SSA.
Regularization.
And, my lord, this judgment, even after a lapse of 2 years, they have not taken positive steps
Yes,
as
it's,
directed.
actually,
However, as submitted by the respondents, my lord, now I have been served with one copy of IA seeking for extension of time.
in the
the IA
disposed of writ petition.
in the
Yes,
writ petition.
disposed of.
So let the IA come up on its own course.
It will come up in its own course. Actually, as you know, it's okay, you file, but something which has expired cannot be extended, actually, in a way. So this was actually directed to be compliant with within 6 months.
6 months.
Yes. But that is long over. In any case, then, but that's okay. The IA will come up with the writ petition in the usual course. But no pleading has also been filed from their side. You file an affidavit, isn't it?
Let them file the exact status, current status.
Current status. Yes. Should I direct that?
Yes, my lord. Because in the recent past, my lord, the submissions they have made is that they have been taking steps again
Yes.
and again. No exact status was given.
They've got a lot of time, actually.
Yes, my lord.
But still, this contempt petition heard. This contempt petition has arisen out of alleged non-compliance with judgment dated 17/3/2023 passed by this court in WPC 128 of 2019. Full stop. The matter pertaining to a direction for considering the prayer of the petitioners for regularization. The petitioner was the Mizoram SSA Teachers Association, represented by its president. The aforesaid exercise of consideration for regularization was directed to be done within a period of 6 months from date of receipt of the order, and the said period appears to be long over. Full stop. As reflected in office note dated 16/1/26, the respondents respond number 1347211 have also not filed any pleadings by way of affidavit in this contempt proceeding. How many respondents are there in this contempt?
As of now, 11, Your Lordship.
There are 11 respondents
11 respondents.
at present.
All are covered,
In fact,
but 2, 5, and 6. 2, 5, and 6. They have changed, they probably. The incumbent has changed.
Incumbent,
Yes.
new incumbent has been appointed.
It is submitted at the bar that today morning, the said respondents have filed an interlocutory application in the disposed of writ petition seeking extension of time
For compliance.
for compliance. Should I direct that IA to be?
No, my lord. No, my lord.
It will come in the usual course. The interlocutory application may come up in the usual course. The respondents herein shall also file an affidavit making known the present status with regard to the compliance with the aforesaid judgment and order dated so and so last petition WPC. Do it. File the.
Yes, Your
no, it's an exercise of a. The exercise needs to be done, isn't it?
Yes, sir.
List the matter after.
After a week, my lord.
How much that will do for you?
After at least
Because,
2
my
weeks,
lord,
Your Lordship.
Yeah,
On the last 2 occasions, they have been seeking time for filing the affidavit.
yes, a lot of time.
Now my clients were on the verge of the retirement, my lord. They have been waiting for
After
the
a
outcome
week?
of this.
2 weeks if possible, Your Lordship. It will take time to communicate the matter to the department as well.
No, there's no problem in
They were
giving 2
already
weeks,
presented, not
provided there is some, some development, some forward movement regarding the process, right? I'm not saying that the court did not say that you regularized. We consider the case for regularization. That's all, isn't it? Okay, list the matter after 10 days.
Yes, my lord.
After 10 days, something in between.
Obliged.
10 days, you want to fix a date? It's always better to fix a date.
31.
30.
Deeply obliged.
Item 2.
My lord, complete set of the TCR has been received, and if this matter may kindly be listed for admission hearing after 2 weeks.
You are for the petitioner?
Yes, my lord.
What
I'm
about-
for the private respondent number 5, my lord.
I see. And you are appearing for the state respondents? 1 to 4. The delay condonation matter?
No, my lord.
No, my lord.
Oh, amendment. Amendment was
Yes, the petitioner had seek
For
for
am-
an amendment,
For,
and that was
for amendment of the plaint.
refused.
Yes, my
Was
lord.
refused. So can you repeat your submission? Sorry, then, you want it after 2 weeks?
Yes, my lord. After
Otherwise, it
2
is
weeks.
ready for hearing?
I'm sorry, my lord.
Is it ready for hearing?
Yes, my lord. It is ready for hearing.
Hearing. So we can admit it also.
my lord, it can be disposed of at the admission stage, my lord.
Yeah, I mean, it can be. We can make an effort. You want it to be kept at the stage of admission only?
Yeah, my lord. If possible, on 10th February, my lord.
So and so. Full stop. It is a learned counsel for the petitioner. Praise for listing the matter after 2 weeks. Full stop. List the matter on
10-2.
10-2. Okay? 10-2.
Obliged.
In the admission column.
Item 3.
Your Lordship, in this matter, I will be appearing for the respondent number 3, which is Kala. I have received instruction. I will be filing my power along with the affidavit within 2 weeks, Your Lordship.
You are appearing for the Deputy Commissioner?
Yes, Your Lordship.
Respond number 3.
Yes, Your Lordship.
Your Lordship, on behalf of the state respondents, that is 1, 2, 4, 5, and 10, the affidavit in opposition on behalf of the state respondents has been filed in the month of December 2025, Your Lordship.
Oh, wrong time. 10
My lord,
So anyone for the petitioner? No?
on behalf of respondent 7, 8, and 9,
I'll just come to you. None appears on call on behalf of the petitioner. Affidavit in opposition has already been filed on behalf of respondent number 1, 2, 4, and 5. 1, 2, 4, and 5. And
7, 8, and 9, we have filed our affidavit on 13 November 2025.
learned counsel so appearing for respondent number 7, 8, 7, 8, 5. What are the respondents?
Your Lordship, the state respondents is 1, 2, 4, 5, and 10. And then the NHIDCL is respondent number 7, 8, and 9. They have filed the affidavit as well.
7, 8, and 9 also file affidavit. Then who's appearing for 10?
Lordship, I'm appearing on behalf of respondent number 6.
6.
Lordship, I seek another 2 weeks' time for filing our affidavit.
Just learned counsel for the union, respond number 6. 2 weeks time to file the affidavit. And Deputy Commissioner, you are appearing.
Yes, Your Lordship.
You have
Respondent
not
number-
filed. You want to file.
Yes, Your Lordship.
Learned counsel for respond number 3, 6. 2 weeks
2
time
weeks.
to file its affidavit. Who's left then? 10?
10 is state.
10 is state, Your Lordship. 1, 2, 4, 5, and 10 is state.
Okay. That's okay. So after these remaining affidavits are filed, the pleadings will be complete, right?
Yes.
list the matter after 2 weeks? After 2 weeks? On 20.
9-2.
9-2.
Item 4.
It's a customs matter.
If I may, my lord, this matter pertains to a discharge of the accused respondents in Sessions case in the criminal proceedings. My lord, there are around 3 provisions that has been violated. Rule 5 and Rule 11 specifically of NDNPS Rules 2022. So, my lord, at this stage, to effectively assist the court, my lord, I would like to have some more time for further research. So, hopefully I can come up with a few citations. So I'm seeking 2 weeks' time, my lord. And in the meantime, my lord, I'm requesting the court to call for the records of the lower court.
Yeah, records should be necessary. They have not called. We can call for the scan copy.
Yes, my lord.
But they have been discharged, right?
They have been discharged.
Discharged, so we can call for the original records also.
My lord.
Because nothing is pending for the court. All the accused persons have been discharged. All the accused persons.
All the accused persons. Yes.
So we can call for the original records.
Yes.
I think, right? Anything from your side?
No, my lord.
Heard, Mr. So-and-so for the petitioner and land counsel so-and-so for the respondent, sole respondent. The instant revision has been filed by the union challenging the order dated 29/8/2024 passed by the learned special judge NDPS Aizawl district in criminal trial number 783 of 24, whereby the respondent was discharged. He was the sole respondent. He was the sole accused.
There are 2 respondents in this case, my lord.
Okay.
2 accused persons.
But only one is impleaded here in this. This is a connected matter. What? Paul Yang Thang, yes. The respondent was discharged. Full stop. The learned counsel for the respondent seeks some more time to prepare the brief and also look up for some case laws. The prayer is allowed. Full stop. How much time after?
2 weeks.
2 weeks, 2.5 weeks.
5-2.
Okay.
In the meantime, my lord, the records.
Yes, sir. Thank you. In the meantime, call for the case record in original of criminal trial number 783 of 24 in the court of the learned special judge NDPS Aizawl. Come to
Obliged.
Item 5.
My lord, I am for respondent number 2. Then I may be granted 2 weeks' time for filing my affidavit.
My lord, with my sincere apologies, my lord, although I have been directed to take steps upon the respondent number 1 and 3 in the last occasion,
Okay.
I have not yet taken it. I'll take
Okay.
if I am granted another time.
Oh,
As per the last court's order, my lord, in respect of respondent number 1, I was directed to take steps by way of registered post. And in respect of respondent number 3, by way of Dusty.
Dusty. Let me have a look at the last order. 411 to
411, my lord,
Your Lordship,
the last para.
yeah. Your Lordship, on behalf of my senior Mrs. Mary Kengte, we will be filing Vakal Nama today for respondent number 3.
No, just a minute. I'll come to you. Just give me 2 minutes. Mr. Learned Counsel for the petitioner submits that he has not been able to take the steps upon respondent number 1 and 3 in terms of order dated 4/11/25 and seeks to do the same. Full stop. The prayer is allowed. The petitioner shall take steps upon respondent number 1 by registered. There is no speed post. Actually.
Speed post.
Speed post. and upon respondent number 3 by Dusty.
My Lord,
Your Lordship, I'm
my learned friend has just entered appearance on behalf of respondent
Oh, I
number
see.
3.
That
So
takes
only-
care of
only
the
for
problem.
respondent number 1 now.
Yes, upon respondent number 1 by speed post, though service upon respondent number 3 was directed, but today learned counsel also have enters appearance. You'll be filing the wakalat number?
yes, sir.
Yes, and
Yes,
submit
Lordship.
that they would be representing respondent number 3 and filing wakalat number shortly. Full stop. Ma'am, yes, you have filed the,
For respondent number 2, I file my power.
you filed already?
I am seeking time for filing my surplus reply.
Counsel for respondent number 2. 2 weeks time to file the file an affidavit. The prayer is allowed. Full stop. That takes care of all.
Yes, my Lord. As for the respondent number 4, already represented, though the council is not present today. They have
Yes.
already filed their affidavit.
Yes. Full stop. Respondent number, it is submitted by the learned counsel for the petitioner that though respondent number 4 is represented, but affidavit has not yet been filed.
Already filed. The council is absent.
Though affidavit has been filed, but the council is not present today. Anyway, so that's okay. Release the matter after 2 weeks?
2 weeks, my Lord.
2 weeks.
9-2.
9-2.
Deeply obliged.
In the meantime, you can file and you can file your.
Item 6.
My Lord, I am for the respondent number 1 and 4. I may be granted 3 weeks time for filing my affidavit.
And yes, my Lord, regarding item, respondent number 5 and 6, the AD card has not yet returned, my Lord. And as per the last order dated 7/10/2025, we were allowed to do a tracking of the consignment against the
Yes.
said respondents, my Lord.
Yes, yes.
And as per the office note 26/9/2025, my Lord, it shows that notice sent to respondent number 5 was tracked, and track consignment shows item bag, but does not show any update thereafter.
Item bag.
Yes, item bag.
Just a minute. So we can await or fresh steps? you
Yes,
like?
my Lord, to await for completion of service, my Lord,
Yes,
regarding
yes.
item 5 and 6, my Lord.
Heard, learned counsels also for the petitioners. Service report is not yet received with regard to respondent number 5 and 6. Await. You are for 4.
1 and 4.
1 and 4. Learned counsel for 1 and 4 seek some time to Union of India and BSF. 2 weeks time. How much time you want, ma'am? 3 weeks. 2 weeks.
3 weeks, my Lord.
3 weeks time to file affidavit in opposition.
Your Lordship,
And 2 and 3.
yes, Your Lordship, same prayer.
Same prayer.
Yes, Your Lordship.
Council for 2 and 3 also has a similar prayer, seeking 2 weeks' time to file affidavit. Prayer is allowed. This is the matter after 3 weeks.
12-2.
12-2.
Item 7.
My Lord, I am for the respondent number 1, and I have filed my affidavit in opposition on 15/1.
Okay. There's only one respondent?
There are 2 respondents in fact, my Lord. There are 2 respondents.
2 respondents.
Although I have taken steps upon the respondent 2 and 3, no service report has come. So far as respondent number 2 and 3 are concerned, my lord, I may be allowed to take fresh steps by way of speed post. They were the cybercrime police station from Tamil Nadu and
I see.
Maharashtra. The matter pertains to illegal freezing of the petitioner's bank account.
Pardon?
Illegal freezing of the petitioner's bank account.
Okay.
The respondent number 1 is the bank wherein I have maintained my bank account.
Okay. Yes. Superintendent of Police, Cybercrime Police Station, right?
Yes, my lord.
Krishnagiri, Tamil
Yes, my
Nadu.
lord.
And this is in Maharashtra.
In fact, my lord, this, as per the direction and instruction of this respondent number 2, my account in the SDFC bank, respondent number 1, has been frozen.
Frozen.
And
IndusInd Bank.
I'm sorry, IndusInd Bank.
IndusInd Bank.
I'm sorry.
Has been frozen. No, it's okay, no problem.
The alleged illegal transaction was occurred on 11/10/2024, 11/10/2024, which can be appreciated from page number 23 and 24, my lord. I'm making this submission because I would like to place the interim prayer, my lord.
Interim order was granted, right? Order dated?
Not yet, my lord.
Not yet order. Not yet.
In page number 23, my lord, this is the bank statement of the petitioner. Page number 23. Annex 3, page number 23.
Just a minute. You are seeking defreezing of the account, right?
Yes, my lord.
Defreezing of the account, which
My
has been
interim prayer is, at this stage, only to keep, to hold lien to the extent of the alleged suspected amount. Now they're freezing the whole account.
whole account. So you want to operate it in a limited way,
Yes, my lord.
while the
During pendency of this
suspected amount remains frozen.
case. Yes, my lord.
What is your submission on that?
My lord, I am only acting upon the instruction of the bank of the police station.
Okay.
If your lordship may kindly see page number 23. On the second column, my lord, there's a account number, account type, currency, lien amount, and the entire balance. The lien amount is 3,06,107. And if you see, may kindly turn to page number 24, the following page. On the middle of the page, my lord, dated 11th October 2024, there's a deposit of 3 lakhs. This is the alleged suspected amount. In spite of the fact that this is the only rupees 3 lakhs is the suspected amount, my lord, they put on lien in excess 6,107. And moreover, my lord, the entire amount, my balance, rupees 5 lakhs plus, was put to frozen.
You want to take the instructions from the...
They have already filed the affidavit, my lord.
Okay.
All they have, the sum and substance of the affidavit is that, as per the direction of the cybercrime unit, they have put to
Yes.
frozen. But the fact remains that it cannot be more than 3 lakhs. And even the respondent number 2 had directed the bank as respondent number 1 to hold lien only to that amount, to that extent, which can be appreciated from page number 30, and that's a 5. Have you got it, my lord? Page number
Yes.
30.
30, I'm on 30.
The second paragraph, my lord. Request to defreeze the below mentioned so and so, and hold only the disputed amount.
I see. It may not be a bad idea to allow her to take the instructions. Will you file a pleading or just take instructions?
I have filed the affidavit in opposition.
You have filed?
Yes, my lord.
Okay. Where is it?
And my lord, I have explained in paragraph number,
You are representing 2 and 3.
representing respondent number 1.
1, the bank.
Yes, my lord.
And who's appearing for 2 and 3?
None appears yet.
None appears here.
Service report is
Oh,
still
okay, I think that has to be. Yes, paragraph.
Paragraph number 11, that, my lord, the reason why the whole account was, is being freezed is because we have received instructions from the Tamil Nadu cybercrime that 3,06,107 is to be put on lien. However, we also received another instruction from the cybercrime Maharashtra that debit freeze has to be done.
There's another
And-
suspicious transaction.
Yes, my lord. And we only acted upon the instruction of the police stations.
Heard so and so for the Learned Counsel for the petitioner, stop, who has filed this instant proceeding, seeking defreezing of his account in the IndusInd Bank, respond number 1, which was frozen by the order dated so and so. Stop. 3 respondents are implicated, including the bank. An affidavit in opposition has been filed on behalf of respond number 1/bank, IndusInd Bank, and the said respondent is represented by Learned Counsel, so and so, who has drawn my attention to para 11 of the affidavit as to why the bank account in excess of the amount of 3,06,107 had to be frozen. It is stated that there was an additional instruction received from the cybercrime police of Maharashtra. Full stop. The Learned Counsel for the petitioner submits that by way of an interim order, he seeks permission to operate part of the account while the amount of rupees 3 lakhs so and so can remain frozen for the moment. However, the concerned police departments implicated as respond number 2 and 3 have not yet been noticed. So would you like to take fresh steps?
In the meantime, I'll take fresh steps.
So because I think let us just hold on the interim prayer for a moment. The petitioner shall take fresh steps by speed post, right? You take it by speed post.
I have taken already since August last year.
Oh, it's not come. Why? Speed post, registered
And
post is
my
not
lord,
there anymore.
Apparently, on the face of it, my lord, there is illegal violation of the procedure, my lord. Section 102 CRPC is there
Yes.
in this regard. There are various judgments of the other high courts also. I can place it before your lordship.
I think no point awaiting, better to take fresh steps to speed up the matter. The petitioner side shall take fresh steps by speed post, EMS, upon the respond number 2 and 3. Full stop. The prayer for interim order is kept open and shall be considered on a subsequent occasion. So let it be.
Additionally, my lord, if I may be also allowed to take alternate steps by way of Dusty, in addition to that.
Dusty?
In addition to the...
Someone has to go there and
we can
because
send
located in
someone,
Tamil Nadu and
because we
Maharashtra.
have been waiting since last year.
Okay. The petitioner side also seeks permission to resort to an additional mode of Dusty service. Prayer is allowed. Do it. The purpose is to serve them so that we can proceed. This is the matter after Take after how long? 2 weeks?
2 weeks, my lord.
To a little more than that.
3 weeks.
3 weeks. 3 weeks.
13-2.
After lunch.
Item 8.
नहीं ठीक अच्छा कर देना ठीक You are for the no. Petition. None appears on behalf of the petitioner. Call. Next up. As per office note dated 16/1/2026, service is awaited upon respond number 1, 4, 5, and 6. Anyone from the other side? None from the other side also. SBI. What's up? No problem.
I'm appear on behalf of the state respondents. We have not received the...
Relax. It's okay, no problem. So service report is awaited on respond number. You are for the?
State respondents, Your Lordship.
1, 2, for the state rise.
Yes, Your Lordship. State respondents is only one, Your Lordship.
Only one, yes.
Yes, Your Lordship.
One to another. It's not necessary. Learned counsel so appears on behalf of. Don't worry, you can just relax. I'm just taking. I was just taking it up. You know, nobody for the petitioner, no. So.
They're still having their lunch, my lord.
Oh, okay, okay. Who's appearing? PC Lanthan for the petitioner.
For the petitioner, PC Lalthangwaya.
Okay, you can write this. No problem. As for the office note, the service is awaited, but one you have already appeared. One, you are representing.
State respondents, DC.
Additional common advocate appears on behalf of respondent number 1, the state respondent. Service awaited on 1 to delete that. 1. You are appearing for?
I'm for respondent number 2 and 3, SBI, my lord.
Oh, I see. 2 and 3 is represented by counsel. This SBI stress asset recovery, this you are not representing. 4 you are not representing, right? 4 and 5 are also related to SBI.
Yes,
and 6,
but it's a Guwahati branch, my lord.
Yes, stressed asset. That is a specific office in Guwahati for stressed assets recovery, branch. So you don't have instructions to appear for
yes,
that.
Yes, my lord, we don't have any instructions.
4, 5, and 6. Then and this is different. So await service upon the remaining respondents, being respondent number 4, 5, and 6. List the matter after 3 weeks.
3 weeks.
After 3 weeks on
13/2.
None appears. We can delete it. We'll give it.
Item 9 and 10.
May it please your Lordship, I am appearing on behalf of the state respondents 1 to 6. Your Lordship, this is the second time the matter has been listed. We are yet to receive pairwise comments. So, Your Lordship, if 3 weeks time may be granted to receive the pairwise comments.
The writ petitioners 272 in number, right? 272 writ. This is, both are connected, right?
Both are connected.
Both are connected. The petitioner side is represented by, you are representing in both the cases, is represented Learned Counsel. And so, and yes ma'am, I have to come back to you again. Your, the Learned Government Advocate appearing for respond number
1 to
2.
6.
1 to?
1 to 6, Your Lordship.
All the six.
Yes, yes, Your Lordship.
All the 6 respondents, being the state respondents, 2 weeks time to file the pleading by way of affidavit.
Your Lordship, 3 weeks time may be granted because
3 weeks.
Yes,
okay.
Your Lordship.
Okay, you have received the pairwise comments.
No, Your Lordship, we have not received yet.
Okay, 3 weeks times to file the pleading by way of affidavit, and further submits that pairwise comments have also not been received as yet. The prayer is allowed. List the matter after 3 weeks on
16-2.
That's okay? 16-2.
Much
Same
obliged,
order.
Lordship.
My lord.
Same order here in this?
My
Yeah.
lord, I have small prayer, my lord.
Yeah, please.
In this WPC number 157 of 2025.
Yes.
In my prayer portion, my lord, prayer portion, which is at page number 76.
I'll just come to it.
Yes, my lord.
Yes, I'm on the prayer portion.
I have just realized that I have made typographical error in my prayer portion.
Okay. In serial number?
Serial number 2, my lord.
You want to correct?
Yes, my lord. The reason is that in the other case, that is only one petitioner that pertains to Group C employee.
Achha.
And here in number 2, they belongs to Group B, C, and D.
I see.
So this portion, if I may be allowed to replace the page number 76.
The petitioner counsel further submits it to only in this,
Only in
157, WP 157.
Yes, my lord.
That typographical error has come to notice in the prayer portion against serial number 2. Serial number 2. And instead of group C, it should be group
B, C, and D.
B, C, and D. The petitioner side 6 to correct the same. How will you'll file a fresh sheet?
By replacing this particular page.
The error appears to be a typographical error and is allowed to be corrected by submitting a fresh sheet to replace this. This will also remain, and you file a fresh sheet. You file a fresh sheet, right?
Only this page, my lord.
Only this page.
Yes, my lord.
Only this page. That's okay. No problem. Only this page.
Much obliged, Lordship.
For orders, item 11.
May I, my lord? There's an interim order which may be continued.
Here, in both the cases?
Yes, my lord.
Both the cases?
Yes, my lord.
The interim order passed white order dated so-and-so stands extended till the next date of listing. It's okay.
There's an interim order in item number 10, WPC 148, item number 10, to maintain status quo.
Okay.
And now both the cases will now club together.
Okay. There's no interim order in 157?
No specific interim order.
Okay. But
the
interim
fact
order of status quo passed in WPC 148. This white order dated so-and-so shall stand extended till the next date of listing. So to some extent, perhaps this will also cover this. But we'll make that extension only in 148.
Yes, my lord.
Right?
Deeply obliged.
Item 11.
In item 11, my lord, I have instructions to appear on behalf of the respondent number 1, that is the claimant, and I will be filing my vakalatnama within a week.
Okay.
And I seek 3 weeks' time to file my objection to the IA.
What is it about? Delay condonation?
Delay condonation,
Okay.
yes.
Filed by the insurance company.
And my lord, in respect of the respondent number 2, there is no return of the ID card.
There's no?
No return of the ID card.
I see. You are for the 1.
I for 1, claimant.
And the respondent number 2 is a necessary party because we have challenged the validity of the insurance policy.
Okay.
Respondent number 2 is vehicle owner.
I see. Yes, yes. Better is there. The learned heard for respondent number 1. Learned counsel enters appearance on behalf of respondent number 1 and submits that they shall file the wakalatnama shortly, full stop, on behalf of the said party, full stop. The learned counsel for the petitioner insurance company submits that services awaited with regard to respondent number 2, and that the said party being the owner of the vehicle is a necessary party as the insurer, as the insurance company is also challenging the said policy, full stop. So we'll await or fresh steps.
My lord.
We'll await.
My lord.
Await service upon respondent number 2. The learned counsel representing respondent number 1 seeks some time to file a written objection. The prayer is allowed. List the matter after. What will be convenient for
3
you?
weeks,
After?
my lord.
3 weeks?
My lord.
After 3 weeks.
17-2.
Obliged.
Item 12.
My lord, in item 12, I have submitted affidavit of dusty service. We have taken steps upon the sole respondent.
Just a minute. Let me come to the cost title.
My lord.
This is also delay condonation?
My lord.
Delay condonation. Okay. Delay of the interlocutory application has been filed under Section 5 of the Limitation Act 1963, seeking condonation of 1782 days. It was calculated as the same?
My lord, yes.
Same. Recalculated, 1782 days in preferring a regular first appeal against order dated 28th July 2018, passed in airship certificate case number 868 of 2018. Quite long time. No? It is submitted that you have submitted the compliance affidavit.
My lord,
yes.
we have submitted.
That dusty service was resorted to with regard to the sole respondent, and compliance affidavit thereof has been submitted. Dusty service was directed by the order dated 3/11/2025. It is stated in the affidavit in para 3 that service was effected on the sole respondent on 17/11/2025. And in the presence of 2 witnesses who signed in the civil form number 28. Copy thereof has been annexed as Annexa 1. In view of the same, the service upon the sole respondent is taken as complete.
My lord.
Should we wait for a date? We can wait for one date.
My lord, my lord.
Yes. List the matter after 2 weeks. 2 weeks will 2 weeks will do.
2 weeks will do, my lord.
2 weeks in the orders column. On that day, it can be taken up on merits.
Deeply obliged.
Okay.
5-2. Hearing list, item 2.
Okay, this is done. We had one more IA, no? Here? There's one more IA. Okay, okay. The earlier matter also there was one more IA. Let's give my notice. Yeah, what is the other IA about?
The IA is for staying the operation of my lord.
Okay, that we can take it up later. See. Okay, we can take it up later on that day. Part 2 hearing list.
May I please, Your Lordship? This is an appeal against the impugned judgment and order dated 23/3/2023, passed in eviction suit number 6 of 2017 by the Court of Senior Civil Judge 3 Aizol. The facts of the case, in brief, is that the respondents have filed eviction suit number 6 of 2017 before the Court of Senior Civil Judge 3 Aizol to evict the appellant from the suit land. And though the written statement was submitted by the defendant, who is the present appellant, an ex parte order was passed by the trial court, and the judgment and order was, the impugned judgment and order dated 23/3/2023 was pronounced by the trial court, wherein the title in respect of a landed property covered by LSC number 3 of 1980 was perfected in favor of the plaintiffs, who are the respondents. And the trial court had also directed the appellant to vacate the suit premises, and also
The decree was passed ex parte.
ex parte.
Ex parte. Oh.
But we're challenging on merits, my lord, because there was no registered deed, registered sale deed. There was.
I'll come to that.
Yes. The trial court, by the impugned judgment order dated 23/3/2023, had directed that the plaintiff number 2, who is the present respondent number 2, is declared as the legal and rightful owner of the land and building covered under LSC number 3 of 1980. And the present appellant shall vacate the land and building covered by the said LSC within a period of 3 months from the date of the order. And the present appellant was also directed to pay arrears of rent at the rate of ₹2,000 per month from 1st January 2017 till date, within a period of 3 months from the date of the order. So, being aggrieved, we are before this court, my lord.
Yes.
The facts of the case.
Yes, let us start with the facts of the case.
The facts of the case is that the wife of the present appellant, H. Lalming Thangi, had mortgaged LSC number 3 of 1980 to one person, namely Srimati R.S. Lalsangswali. The mortgage amount was ₹2 lakhs, and the mortgage was made on 29/9/2007. And thereafter, the said R.S. Lalsangswali mutated the said LSC number 3 of 1980 in her name.
Okay.
And subsequently, she sold the said LSC to the said landed property to Sri Lal Swana, who is the present respondent number 2.
Okay.
And mutation of names in the revenue records was done accordingly, and now the LSC is registered in the name of Sri Lal Swana, who is the present respondent number 2. Since the LSC was in his name, accordingly, together with PC Lianmura, they have filed the eviction suit number 6 of 2017 for eviction of the said Lalming Thangi along with her family from the premises. However, Lalming Thangi had died during the pendency of the suit, and she was substituted by the present appellant, who is C. Zauram Liana. My grounds of appeal can be seen.
The present appellant was
C. Zoram Liana.
yes.
She had substituted the
Late.
deceased H. Lam Hing Tangi.
Yes. She was the sole defendant
Sole defendant. He was the sole defendant.
in the suit, right?
And he has been in occupation of the suit land till date. If your lordship may kindly turn to the documents which I've annexed in the memo of appeal has not been included in the paper book for some reasons. So, my lord, if I may be allowed to.
Okay. They have not been annexed to the paper book?
Yes. They've only taken out my memo of appeal without the annexure.
I see.
So, if I may be
It is in the LCR record?
allowed to rely on some documents from my memo of appeal.
The documents would be in the exhibit document, I think. Exhibit 5. Okay, we have some documents here. We
Yes.
have some documents from your memo of appeal.
Yes, my lord.
Right? We'll take up from there.
Page 34, my lord.
Otherwise, the record has been received, right? The trial court record has been received. Yes, it should be. All the documents.
Page 34 is the document of
Only
mortgage.
check it once. No, should just see whether all the documents are there. It must have come. Anyway,
Yes.
let's proceed. Yeah.
Page 34 is the document of mortgage, and page 36
Page 34 of your
yeah, memo of appeal
memo of appeal.
is
Okay.
the document of mortgage,
Mm.
and page 36 is the English translation. With your lordship permission, if I may read.
Please. I,
Permission to mortgage land. I, Tan Chung, resident of Duik Walnut, grant permission to mortgage my land LLC number 3 of 8/1980 to our daughter-in-law, Arlal Himpui, wife of Sizoram Liana Dinthar, to fulfill her agreement with R.S. Sangzo, the daughter of T. Sena Dintharwan. If upon failure to pay back the sum of money owed, I promise to immediately give up my land. There was 2 witnesses, and the landowner had put her signature. And this was the only document executed between the landowner and R.S. Sangzwali, who had mutated and transferred ownership of the said landed property in her name. In this connection, my lord, I would like to draw your attention to the Registration Act 1908,
yes.
Section 17.
Registration Act.
Section 17, my book is professional book publishers, and it's page 11, section 7.
Yes, I've got it. Documents for which registration is compulsory.
Yes. With your lordship permission, if I may read.
Yes.
The following documents shall be registered if the property to which they relate is situated in a district in which, if they have been executed on or after the date on which Act 16 of 1864 or the Indian Registration Act 1866 or the Indian Registration Act 1871 or the Indian Registration Act 1877 or this act comes into force, namely A, instrument of gift of immovable property. B, other non-testamentary instruments which purport or operate to create, declare, assign, limit, or extinguish, whether in present or in future, any right, title, or interest, whether vested or contingent, of the value of 100 rupees or upwards, true or in an immovable property. Now, what Section 17 says is that if the value is more than 100 rupees, it has to be compulsorily registered. And this permission to mortgage landed property has not been registered as per law. That is number one of my ground, my lord. My ground of appeal. And Section 49 of the said act, my lord.
Consequences.
Yes. Effect of non-registration. Effect of non-registration of document required to be registered. No document required by Section 17 or by any provision of the Transfer of Property Act 1882 to be registered shall A, affect any immovable property comprised therein, or confer any power to adopt, or B, receive as evidence or any transaction affecting such property conferring such power, unless it has been registered. So, since the document has not been registered, as per law, the title cannot go to R.S. Lal Sangswadi. That is my ground one of my...
Principal ground.
Yes, principal ground. And one more thing, I would also like to place reliance on the judgment of this Honorable Court reported in 2013, Volume 4, GLR, page number 53.
Can you repeat 2013 4 GLR?
2013, Volume 4, GLR, Guwahati Law Reports, page 53. It was the judgment of Justice Ujal Buyan, and the parties were Sam Lura Silo and Sila Rampari. This is also a case where title has been granted and eviction order was passed in an eviction suit, but wherein there was no registered document.
Okay.
I'll start from para number 21, my lord, page 57. If I may be allowed to read, my lord.
Yes, please.
Section 17 of the Registration Act 1908 deals with documents of which registration is compulsory. As per Section 17(1)(b), other non-testamentary instrument which purport or operate to create, declare, assign, limit, or extinguish, whether in present or in future, any right, title, or interest, whether vested or contingent, of the value of 100 rupees and upwards, true or in immovable property shall be registered. Thus, a sale deed of land having a valuation of more than 100 rupees is mandatorily required to be registered. As per Section 23, such registration is required to be done within 4 months from the date of its execution. In exceptional cases, the registrar may accept such documents for registration beyond the period of 4 months, but not exceeding 4 months as provided in Section 25. Therefore, if the document extended period under Section 25 is taken into consideration, a document covered by Section 17
4 plus 4, 8 months.
Yes,
right?
has to be presented for registration within 8 months at the maximum from the date of its execution. Under the Indian Stamp Act, Mizoram Amendment Act 1996, in the case of sale of immovable property whose valuation exceeds rupees 10 lakhs, stamp duty of rupees 47,500 plus 10% of the value above rupees 10 lakhs is required to be paid. Having noticed the legal position as indicated above, let us again examine the two crucial documents in question, one dated 23/7/2007 and the other dated 24/7/2007, which have been discussed in the preceding paragraphs 19 in some detail. The document dated 23/7/2007 is admittedly not registered. No stamp duty has been paid thereon. As already stated, possession of the property was also not handed over to the plaintiff. Insofar as the document dated 24/7/2007 is concerned, though it is shown to have been registered, the registration is clearly beyond the period prescribed under Section 23 and 25 of the Registration Act 1908. The deed was executed on 24/7/2007 and registration was done on 1/7/2008. That is after almost 1 year. As per the aforesaid provisions, a document for registration can be accepted within 4 months, can be extended for a further period of 4 months, that is for a total of 8 months. In the present case, it is clearly beyond even the extended period of 8 months. Therefore, the said document dated 24/7/2007 cannot be said to have been validly registered. No stamp duty was also paid along with the said document, and as already noticed, possession was also not handed over to the plaintiff. The plaintiff in her evidence only stated that the revenue authorities had mutated her name in respect of LSC number 110 of 1976 on 24/7/2007, that is within 1 day of the presentation of the deed dated 23/7/2007, which only goes to show that the total non-application of mine on the part of the revenue authorities. On the strength of the two documents, grant of mutation and failure of defendant to pay rupees 15 lakhs with the stipulated interest as per the buyback clause, plaintiff claimed title over the said land and building. In State of Orissa and others versus Brundaban Sharma and another Supra, Honorable Supreme Court held that an honest order is a void order and it confers no title, and its validity can be questioned or invalidity can be set up in any proceeding or at any stage. In the case of Amar, Sina and others Supra, the Apex Court reiterated the settled law that mutation entries are only for the purpose of enabling the state to collect land revenue from the person in possession, but it does not confer any title to the land. The title would derive from an instrument executed by the owner in favor of an alienee as per the Stamp Act and registered under the Registration Act. In Bondar Sina Supra, the Honorable Supreme Court clearly held that under the law, a sale deed is required to be properly stamped and registered before it can convey title to the vendee. In Macmala and others Supra, the Apex Court again stated in clear terms that it is settled legal position that an agreement to sell does not create any right, title in favor of the intending buyer. The legal position as discussed above has been aptly summarized by the Honorable Supreme Court in the case of Suraj Stamp and Industries Private Limited Supra, wherein the Apex Court has held as under. It is thus clear that a transfer of immovable property by way of sale can only be by a deed of conveyance, sale deed. In the absence of deed of conveyance, duly stamped and registered as required by law, no right, title or interest in an immovable property can be transferred. Any contract of sale, agreement to sell, which is not a registered deed of conveyance, deed of sale, would fall short of the requirement of Section 54 and 55 of the Transfer of Property Act, and will not confer any title or transfer any interest in an immovable property except to the limited right granted under Section 53A of the Transfer of Property Act. According to the Transfer of Property Act, an agreement of sale, whether with possession or without possession, is not a conveyance. Section 54 of the Transfer of Property Act annexed that a sale of immovable property can be made only by a registered instrument, and an agreement of sale does not create any interest or charge on its subject matter. In view of the settled legal provision as indicated above, deliberation on the aspect of fraud urged by the appellant is considered not necessary. B.L. Sridhar and others versus K.M. Munir Reddy, that and others relied upon by the respondent is a case which deals with the concept of estoppel. The said decision can be of no assistance to the respondent as the present case is clearly distinguishable on facts. Moreover, when the so-called sale is void, there can be no estoppel preventing the aggrieved party from raising a grievance as to the invalidity of such sale. Likewise, Jaina Rain, Paras Rampuria Det versus Puspa Devi, Saraf and others relied upon by the respondent was decided on facts which are clearly distinguishable from the present case. Principle of estoppel cannot be invoked in a case like the present one. In view of the discussion made above, this court is of the unhesitant view that no sale of land and building covered by LSC number 110 of 1976 as understood in law had taken place. Therefore, the impugned judgment and decree dated 21/12/2010 passed by the learned senior civil judge Aizol in eviction suit number 1 of 2009 is wholly unsustainable in law. The same is accordingly set aside and quashed. Consequently, all the other orders passed in execution case number 12 of 2011 by the learned senior civil judge through Aizol would also stand quashed. RFA 25 of 2011 and RFA 34 of 2011 are accordingly allowed. However, looking to the facts and circumstances of the case, there shall be no order as to cause. So herein, my lord, there was permission to mortgage a land, and if I may draw your lordship's attention to page 37
Page 37 of the...
of my memo of appeal, annexure 4. This is a sale deed.
Page 34.
Yes, this is a sale deed, and the translation is at page 39. This was also not a registered document.
Okay.
So, the trial court having perfected title in favor of the respondent number 2 without any valid
The
sale
mortgage, this was made and then subsequently the sale deed.
Yes. Permission to mortgage land was made by the landowner Tan Sungi, wherein she had allowed her daughter-in-law to mortgage her LSC to R.S. Lal Sangswali.
For sum of money.
And by that document, without executing any sale deed whatsoever, the LSC was mutated in the name of R.S. Lal Sangswali. And thereafter, R.S. Sangswali had executed a sale deed in favor of the present respondent number 2, which was also not a registered document. And thereafter, by this sale deed, which was not registered, the respondent number 2 had approached, R.S. Lal Sangswali had executed a sale deed in favor of respondent number 1. I'm sorry, madam. And the respondent number 1, along with the respondent number 2, had approached the court for eviction of the present appellant, who is the original owner of the LSC, who is the son of the original owner of the LSC. And one thing very surprising is that, my lord, the LSC, when it was transferred in favor of R.S. Lal Sangswali, that was on the property in dispute was transferred in favor to R.S. Lal Sangswali on 4/5/2011 from the name of Tan Sungi, which can be seen from page 8 of the paper book, my lord. It's a bit hard to read, but
Annexure A, it's written, right?
Annexure A.
Page 8.
Yes, Tan
So,
Sungi.
certificate of land settlement.
Yes, Tan Sungi name was cancelled and R.S. Lal Sangswali name was also again cancelled. However, 1, 2, 3, 4, 5, 6, just below the column, my lord, if you can see, transferred to R.S. Lal Sangzwali, Vibe number S11026, so and so. Signed by the Assistant Settlement Officer on 4/5/2011. However, during that time, the original landholder, Tan Chung, had already expired, and she was not in a position to sign any document. And I have annexed the death certificate of Tan Chung. Unfortunately, it has not been included in the paper book, but it's in page 40 of my memo of appeal. Page 40 of my memo of appeal, annexure 5, wherein it can be seen that the original landholder, Tan Chung, had died on 6/11/2008.
Okay. Page?
Page 40, my lord. Page 40, 40.
40.
Of my memo of appeal.
She had died in 2008
Yes, date of death, 6/11/2008.
itself.
Yes. It's at 1, 2, 3, 4. Paragraph number 5.
Yes, yes, I got it.
Yes, date of death, 6/11/2008. So, though she might have executed a permission to mortgage the land, she could not have executed any sale deed when the property was transferred by the Revenue Department. So, my humble submission is that, my lord, the impugned judgment order passed by the Court of Senior Civil Judge is untenable in law because all the documents which were used for mutation was not a registered document, and the respondents herein could not have claimed title in respect of an unregistered document.
You're contending that basically there was never any valid transfer of property.
Yes, there was never any valid transfer of property. So it deserves to be set aside. That is my humble submission, my lord.
You are appearing for the?
For the respondent number 1 and 2, my lord.
Any, who's for 2?
2. 1 and 2 both.
Oh, okay. That's fine.
May it please your lordship.
Yeah, just a minute. Okay.
Firstly, your lordship, I would like to point out the prefix in the plain, which is in the paper book. I would like to rephrase it again. The LSC number 3 of 1980. It is in, the plate is in page number 1.
Before proceeding further, I hope these documents which he has, because I can always look up from this appeal memo, but still I have to cross-check, you know. Of course, it's as a procedural duty on part of mine. So it should be in the this thing in the TCR, the trial court records. Can you check it once, Land Council, from the record? Because otherwise. Otherwise, you have annexed everything, so if there is no objection, I can go by this also. The exhibit file probably, I don't know, it looks little thin. You can have a, you can cross-check. In the meantime, you can proceed, perhaps.
Yes, my lord. Thank you, my lord.
Or maybe just check it once. Yes, it will be better. Mr. Counsel, for the appellant,
Yes, my
you
lord.
can also
Yes.
you can also help him. Just check it once. Because since we will take this to the stage of judgment, that is why we are checking things. Do we have all the papers before us?
My lord, the documents which I've annexed in my memo of appeal is not included in the TCR because the plaintiff themselves have not annexed. They have simply annexed their land settlement certificates.
Okay.
And they have
It's not available here.
It's not available here.
So can I proceed if
Yes,
you
yes.
don't have any objection? So I'll use the documents from your appeal memo and the remaining from here,
Yes, my lord.
right? Okay. So that the matter can proceed. Okay. Otherwise, we'll have to call for again.
Yes.
You know?
Yes, sir.
My lord, again, I would like to point out that the LSC number 3 of 1980 was mortgaged by way of deposit of title deed by H. Lal Ming Thangi.
Okay. We
Now,
go to page
page number 1 of the paper book.
page number 1 of the paper.
Which is the plaint in the eviction suit 6 of 2017.
Okay. Page number 1 is the.
Yes, para number 1.
Yes.
Page number 1.
Yes.
I'd like to again point out that the LSC number 3 of 1980 was mortgaged by the defendant. That is, the original defendant, Mrs. H. Lan Ming Thangi, to Srimati R.S. Sangswali by way of deposit of title deed was mortgaged by availing loan of rupees 2 lakhs, which is on 29/9/2007. Again, my lordship, I would like to point out that as Mrs. H. Lal Ming Thangi could not repay the said rupees 2 lakhs within the stipulated time, the said LSC number 3 of 1980 was transferred in the name of Mrs. R.S. Sangswali. Again, from the said LSC number 3 of 1980, the said LSC was again sold by Mrs. R.S. Sangswali to the respondent number 1 in the instant appeal, who is the plaintiff number 1, P.C. Liangura, for a sum of rupees 4,70,000. However, before mutation of name from R.S. Sangswali to P.C. Liangura, the said P.C. Liangura, the plaintiff number 1 in the eviction suit, again sold the landed property to the respondent number 2, who is the plaintiff number 2 in the lower court, for the same said amount of money, that is 4,70,000.
Okay.
After all the sale process was done, and after mutation was done in the name of the plaintiff number 2, who is the respondent number 2 in the instant appeal, Srimati H. Lal Ming Thangi, the original defendant in the eviction suit, filed a case against Mrs. R.S. Sangswali and 5 others for declaration of title, ownership of the land covered under LSC number 3 of 1980, and for declaring that the agreement dated 29/9/2007 as null and void, and the same was registered as declaratory suit 8 of 2010. My lord, can we, if you could please turn to page number 13 of the said paper book.
Copy of order passed by.
Yes, yes,
so
yes,
as
yes, my lord.
Subordinate District Council Court.
The said declaratory suit number 8 of 2010, which was filed by Mrs. H. Lal Ming Thangi, was dismissed as per the said order, dated 11/4/2011, as per Order 9, Rule 3. Again, after the said case was dismissed, Srimati H. Lal Ming Thangi again filed another suit against R.S. Sangswali and 5 others, and the same was registered as declaratory suit number 5 of 2013. However, the said declaratory number, suit number 5 of 2013, was withdrawn by Srimati Lal Ming Thangi with the liberty to file afresh on 26/4/2013, which can be seen on page number 14 of the paper book. Again, after the said declaratory suit number 5 of 2013 was withdrawn, again, Mrs. Lal Ming Thangi, H. Lal Ming Thangi, again filed another suit against the respondents in the extent appeal and 7 others. and the same was registered as declaratory suit 25 of 2013. However, the said declaratory suit number 25 of 2013 was dismissed by the Honorable Senior Civil Judge on 8/9/2016, as per Order 6 Rule 14, which is in page 15 of the paper book. My Lord, if I can read out some portions of the
Yes.
said order.
Let us read this. Page 16. Right?
Yes, page 16. Coming to para number 2, it can be seen that while the learned counsel for the defendant number 3, 5, and 6 cross-examined the plaintiff for plaintiff evidence, she deposed that it is a fact that Exhibit P1A, P2A are not my signatures. I do not know whether the signature in Exhibit P5 above the name of Lalming Thangi is my signature or not. I do not know the contents of Exhibit P1. Here, the Exhibit P1 is plain, and Exhibit P2 is affidavit submitted by the plaintiff, which meant that the plaintiff and its affidavit are not duly signed by the plaintiff, and the plaintiff even do not know the contents of her plaint. Further, the plaintiff is not sure about the signature in Tu Intiamna Lekha also, which is Exhibit P5, and it is a vital evidence for the instant dispute. Therefore, the court feels that the case could not proceed further as the pleading of the plaintiff is not duly signed by the plaintiff as per Order 6, Rule 14 of CPC 19.8, which is a mandatory provision. Then the court heard both side counsels as agreed, and there is no objection from any of the counsels for dismissing the instant suit. Hence, the instant suit, that is declaratory suit number 25 of 2013, is dismissed due to procedural
On
lapse
procedural grounds.
and not following the mandatory provision. After the said declaratory suit number 25 of 2013 was dismissed, the plaintiff number 2, who is the respondent number 2 in the instant appeal, served a legal notice to Srimati H. Lalming Thangi to give vacant possession of the land covered under LSC on or before 31st December 2016. So the said, my lordship, the said legal notice is in page number 18 and 19 of the said paper book. And as the said Srimati Lalming Thangi did not give vacant possession of the land covered under the said LSC, the instant eviction suit number 6 of 2017 was filed by the instant respondents 1 and 2 as plaintiffs in the trial court. Before the written statement was submitted by Srimati H. Lalming Thangi, she passed away on 3/4/2018. And she was substituted by her son, namely Zauram Liana, who is the instant appellant in the instant appeal. The instant appellant as defendant in eviction suit 6 of 2017 filed a written statement through counsel. My lord, if we can see page number 22 of the paper book.
Yes, I am on 22.
22. That is the written statement submitted by the defendant through counsel, instant appellant through counsel. It can be seen from the prayer made by the instant appellant as defendant. The instant appellant as defendant only prayed for dismissal of the instant suit. That is the eviction suit 6 of 2017. No counterclaim was made by the defendant appellant. Further, no annexure was made except the death certificate of her late mother, Srimati H. Lalming Thangi, in the original document in the lower court. Only the death certificate was submitted annexed by the defendant, instant appellant as defendant in the lower court, in the trial court. No counterclaim was made, and further, no prayer was made by the instant appellant as defendant in the eviction suit 6 of 2017. Further, The counsel for the appellant as defendant in the eviction suit 6 of 2017 withdraws herself from the eviction suit 6 of 2017 due to whatever reason known between them. Hence, someone was served to the appellant as defendant by the trial court. After several summons were served, and as the appellant as defendant in the trial court failed to appear before the trial court, an application under Order 9, Rule 6, was filed by the respondents as plaintiff in the trial court. And the same can be seen in page number 25 of the
Yes, I've seen.
paper book.
An ex parte order
Yes,
was made.
Then an ex parte order was made on 23rd March 2023, which can be seen on page number 38 of the paper book. The ex parte order can be seen. Page number 38 of the paper book. Then, after plaintiff evidence were taken and after hearing the counsel for the plaintiff by the trial court, the Honorable Senior Civil Judge passed the judgment, order, and decree on 23rd March 2023. Coming to the judgment, order, and decree passed on 23rd March 2023, my Lordship, if you can please turn up to page 63 of the paper book, which is the judgment and order. Coming to point number 12 of the said judgment order under the heading argument, it can be clearly seen that, my Lordship, if I can just read out.
Yeah, I am on that.
Point number 12. Heard the learned counsel for the plaintiff and received a written argument. The learned counsel for the plaintiff submitted inter alia that even after an ex parte order was passed by the defendant, the court still gave a chance to the defendant to appear before the court for cross-examination of both the parties. The court, by order dated 21/9/2022, White Memo number 298 SRCJ 2022, invited the defendant to appear before the court on 10/10/2022 for cross-examination of both the plaintiffs. However, even after receipt of the said order, the defendant failed to appear before the court. The court, again by giving order dated 21/10/2022, White Memo number 338 SRCJ 2022, invited the defendant to appear before the court on 21/11/2022 for cross-examination of the plaintiffs. However, the defendant again failed to appear before the court. It is thus clear that the defendant had no intention to contest the case, no defendant's evidence in support of his case. The written statement had not been proved by way of evidence. From the evidence on record, it is clear that the plaintiffs were entitled to the relief claim. Hence, from the opinion of the Honorable Senior Civil Judge, the defendant had no intention to contest his case. Thus, the Honorable Senior Civil Judge was making a just decision while passing the judgment and order and decree dated 23rd March 2023, and the same should be upheld by this Honorable Court. Further, my Lord, with regard to the instant memo of appeal petition and the grounds of appeal, I would like to point out that the instant appeal petition, not only does the instant appellant have prayed for setting aside and quashing the judgment and order and decree dated 23/3/2023. Further, the instant appellant also prayed for declaring the documents dated 29/9/2007 and the sale deed dated 1/6/2011, which was mentioned earlier by my learned friend in his hearing. However, for declaring the said two documents as null and void. Further, The instant appellant also challenged the mutation from the name of so-and-so. With regard to the documents dated 29/9/2007 and the sale deed dated 1/6/2011, I'd like to again point out what I have already pointed out before, which is that the instant appellant as defendant in the trial court submitted a written statement in which only the instant appellant as defendant only prayed for dismissal of the instant suit. That is eviction suit 6 of 2017. No counterclaim was made by the defendant. Further, the only annexed along with the written statement is the death certificate of her late mother, that is Srimati H. Lalming Thangi, who is the original defendant. The said documents were never mentioned, never challenged, and mutation was also not challenged in the lower court. Hence, the plea not raised, which was not raised in the original court, will be deemed to have waived and cannot be raised in the appellate court. With regard to this, my lord, I would like to submit several case laws. My lord, the first case is regard to Vanelzuata versus HKL Thanga. In para number 13, which is page 7. Para number 13, which is page 7. My lord, if I can read it out, those relevant points.
Yes.
And further, as stated above, the defendants did not categorically state in their written statements that the plaintiff has waived his right or assert or challenge the validity or otherwise of the said resolution number 6. Again, the defendants did not claim for any issue to be framed to cover their plea of the fact of waiver before the trial court, and therefore it can be taken that the defendants have waived their plea. After all, a plea not raised in the original court will be deemed to have been waived and cannot be raised in the appellate court. In this connection, we may refer to the decision made in Prabhal Singh Nathu Bhai versus Santilal Nagi Bhai, AIR 1982, Gujarat 136. In the said case, it was largely held that a plea which was not raised in the original court will be deemed to have been waived and cannot be raised in the appellate court. Again, my lord, another judgment, that is Krishna Pasuba Rao Kundapur, that after him, his legal representative.
Yes.
Versus Dattatrava Krishna Ji Karani. In the said judgment, it is held that Civil Code of Civil Procedure 1908, Section 100, new plea, where a plea of res judicata was not raised before the courts below in the High Court, the same cannot be raised for the first time before the Supreme Court. Again, my lord, I would like to point out another case law, that is Jagnesh Warnath versus Jatra Mohan Sarkar. If we come to page number 3, that is para number 4. Page number 3, para number 4. I have
para 4.
Para 4. In the last part, I have made it bold.
That part, no?
Yes.
Starts like that.
Yes. Therefore, in my opinion, the plea of non-joinder of Jibananda's mother having not been taken up specifically the defendant appellant is not entitled to raise the plea at the close of trial. Further, this point was never agitated before the first appellate court. As such, must be deemed to have been waived. My lord, from the case law submitted before your lordship, it can be seen that whatever grounds not mentioned and whatever ground not mentioned in the trial court, and whatever document is not challenged in the lower court, in the trial court, cannot be challenged in the appellate court. Hence, the documents dated 29/9/2007, the sale deed dated 1/6/2011, and further, the challenge of mutation of the LSC number 3 of 1980 cannot be challenged before this appellate court. Therefore, it is therefore most humbly prayed, Your Lordship, that may be graciously pleased to dismiss the instant appeal.
Any reply from your side?
Yes, my lord. Our appeal is on a question of law, my lord. And your lordship is well aware that question of law can be raised in any proceedings, even at the last resort. The question we pose before your lordship is whether an immovable property can be transferred without a registered sale deed, without a registered document. And we are the defendant in the suit, and an ex parte proceeding was drawn against us. We were not the claimants therein, they were the plaintiff. And whatever claim they have made, there was no registration of document. And the law says that in order for an immovable property to be transferred, it has to be done as per law, that is by way of a registered document. So, my lord,
Delegate, your
I think your lordship heard the matter, yes, my lord.
Okay. We'll reserve.
Yes, my lord.
Write it down.
Obliged, my lord.
Heard so and so. Arguments concluded. Judgment is reserved. Deliver it as quickly as possible. Go through it. And this point, you can attach these 3 sheets. Stapler is there. Stapler. Just staple it. Okay.
Obliged, my lord.
Obliged, my lord.
Any other matter? Oh, this one. Keep it. Any other hearing matter? No. 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 These also, this case was. Okay.